Hi, my name is Jonathan Healy. In this 10-minute iTOO expert film, I discuss iTOO's Directors and Officers Liability cover. What is Directors and Officers Liability cover? Directors and Officers Liability Insurance is an insurance policy that protects directors and officers in their personal capacity following allegations of wrongfulness or breach of their fiduciary duties to the company and to any affected stakeholder. What does iTOO's Directors and Officers policy cover? We split our cover into three main insuring clauses, being Side A, Side B, and Side C. Side A cover is an insurance for the individual director or officer in their personal capacity following an allegation of a breach of their fiduciary duty both to the company or to an affected third party. Side B is a reimbursement policy for the company where they have paid the costs or defense for a director in terms of their memorandum of incorporation and seek to have that cost reimbursed under the insurance policy. Side C is a policy for the entity for where there has been a breach or allegation of breach of a securities regulation. Each of these insuring sections are underpinned by advanced defense costs, and these costs can be triggered under each of those insuring sections and are on an advanced basis. This means that any director or officer who is held to be responsible can trigger the policy and incur the costs for their defense right up until a final adjudication of the matter under the insurance policy. Why is D&O a big risk right now? The 2008 Companies Act encodes the fiduciary duties which directors and officers are responsible for and are required to act in terms of their provision of services to both their companies and to affected third parties. Directors and officers are required to act in terms of these fiduciary duties and to demonstrate that they have understood both the risk in their businesses and have implemented the necessary mitigation to protect their companies against such risks. It is ultimately the board's responsibility to both understand that risk environment and to demonstrate that they have implemented the necessary mitigation steps. We are operating in an increased regulation and compliance requirement framework for most industries around the world, and directors and officers are ultimately responsible for demonstrating their understanding of that risk and for implementing the necessary mitigation steps in their companies. As a result, directors and officers have a widening net of liability, and this liability could potentially be on a civil basis, on a regulatory basis, or even a criminal basis. In certain instances, an allegation against a director could be such of criminality or fraudulent activity, and in those instances, you could have a director's assets being frozen. There would still be a number of expenses which would need to be incurred by that director or officer, such as things like school fees, bond repayments, etc. Whilst the policy responds to defend the director until the final adjudication on the matter, the policy can also then respond to those certain costs that the director has to incur whilst the allegation is unfolding, and the policy can pay the third-party costs on behalf of the director. It's very important at this point to note that while the policy does respond to defend a director following allegations of fraudulent or criminal behavior, the intention is to ultimately find what is the outcome of that matter and whether or not that director is ultimately found to be liable criminally or fraudulently. We will never, however, cover a fraudulent or criminal action, and so whilst we defend a director and advance the costs, should that individual ultimately be found guilty, we would reimburse those costs or seek to get those costs back from the individual director so that we are not covering a fraudulent or criminal act. How does iTOO's D&O cover differ from others in the market? Whilst we provide the same core insuring clauses, being the Side A, Side B or Side C, we also extend our cover to certain costs and expenses which can be incurred in addition to the main insuring clauses, as well as extensions of cover which are applicable to losses in the directors and officers space. Further to that, we also have fewer exclusions which we believe are relevant often in claims that are made against directors and officers. And for example, we do not as a standard exclude insolvency actions, and we do not exclude insured versus insured actions, and we do not as a standard exclude major shareholders. We also provide a reinstatement of Side A as an automatic extension to our cover. Where a policy is triggered under a Side B or a Side C claim, and the limit of indemnity which is purchased under that policy has been used up by either of those triggering sections, we will automatically reinstate the Side A cover. This means that a director or officer is always covered in their personal capacity under the Side A clause at no additional cost, and this should create a lot of comfort for our clients. How does a person take up cover with iTOO? Directors and officers liability is a cover that is purchased by a company on behalf of its directors, and this is authorized under the Companies Act, which allows for companies to purchase this insurance on behalf of its directors. So we do not place this cover for individual directors in their personal capacity, but rather for the company who will purchase the policy on behalf of its directors. As an underwriting manager, iTOO is not authorized to engage in the placement of directors and officers insurance directly with the public, and so we work through our extensive broker network. Should this be a relevant policy to you and to your directors, please get in touch with your brokers and request that they receive a quote from iTOO. What is required when applying for iTOO's directors and officers insurance? We require a completed proposal form as a minimum. This will take us through the basic information of the company, as well as give us a direction as to what is the nature of the business and how the compliance requirements are exercised within the business. We also will request a completed set of financial statements, and we do a thorough analysis of those financial statements to understand who the directors are, what are the solvency ratios, what are the liquidity ratios, and how the business has developed over time. We use both the financial statements and the proposal form to understand the risk and to then quote accordingly. We may request other supporting information at time, for example, feedback on how businesses have responded to the COVID-19 pandemic and what mitigation steps have been implemented. These supplementary questionnaires will be requested on a case-by-case basis, but may form part of the additional information required in order for iTOO to provide a competitive quote. Things to remember about the iTOO Directors and Officers policy. Directors and officers insurance is purchased on behalf of the directors and officers of a company, and so it is very important that you as a director or officer understand the cover that you have under this insurance policy, but more importantly to also understand what is not covered. Ask your company for the policy and make sure that you have read and understood both what is covered and what is not covered. Understand what the claim requirements are and the notification requirements are under the policy. Should you need to trigger this policy in response to any allegation made against you, we do have certain claim notification requirements, and it is very important that those are followed under the policy. We also request that at the beginning of the placement of this insurance, accurate information is provided and disclosed so that we can make our assessment of the risk and that we can provide you with the best possible insurance quotation. Why should a person choose iTOO? At iTOO, we pride ourselves on being solution-orientated in our underwriting. As far as possible, we will try to find a solution for your particular risk. We have a very open approach to our underwriting, and we will always be able to disclose right up front what our risk concerns are and allow for our clients via our brokers to make the necessary disclosures to understand the risk and for us to provide the best solution. Our claims experts have vast experience in directors and officers liability claims and can also support through third-party panelists to provide our directors and officers with the best possible claims support and solution following an allegation of wrongfulness. At iTOO, we don't only sell insurance. We provide our clients with freedom and security to realize their goals by sharing in their financial risks in these times of major uncertainty. For more of our 10-minute iTOO expert films, where we discuss other iTOO products and services, please explore itoo.co.za. Thank you.